Good morning, everybody. This is all very new to me because I am working with software that I've never worked with before, and I welcome Reyno with us. So you're going to see myself and Reyno, and you're going to be seeing the Liberty Fighters logo with Reyno sitting in court, because this is what today's meeting is all about. So you that have come online, there's quite a few of you watching at this stage. I want you to send out the link to this live stream. Reyno, welcome. Thank you very much for everything that you've done for the country. All my supporters are backing you. They watched the diehard supporters watched the live stream yesterday, and they shared it far and wide. And I hope that you will have an opportunity to speak to the people and tell them now what is actually your main aim with this court case, what's actually in the papers, because in the court case itself there's a lot of legal jargon, and you certainly sounded like a professional, I must say. And I think just in layman's terms, people are so interested in what you are doing. They call you a South African hero, and I see you as that. I look up to you as a person. As I've told them before, that it's people like you that keep me going in what I'm doing right now. So if you could just please tell the people what this court case is about, what Reyno De Beer is about, and then about the Liberty Fighters Network, because I want the people to support your organization and what you are doing.
Thank you very much, Des, for inviting me. We've spoken a lot over the phone and on WhatsApp a couple of weeks, and it's good to eventually be on your show. Thank you very much for the support and for what you are doing. Without people like you, the word can't go out, and that is the most important thing. That we as the people working in the background can't succeed without the people's support, and the only way that the people's support can reach us is by way of people like you. Thank you very much for that. Desmond, let me just give an indication of what the court case against the government is all about, where Liberty Fighters Network is involved. We've lodged this application because of the fact that our work entails mostly of helping land or tenants in landlord-tenant disputes. We do focus on landlords as well, but they have lesser problems with rent-related problems than the tenants actually do, because at the end of the day, the tenants are the ones who are being pressured to make their payments, their rental payments, when the landlord demands it, and the landlord usually is adamant, and they usually entail mafia type of tactics like illegal disconnection of electricity or illegal. So in the first 3 weeks of the lockdown, Liberty Fighters Network got stuck with something like 3,000 people and tenants who complained to us that they were unable to make a rental payment, and they were basically haunted by their landlords, and they faced tremendous hardships in reactions by the landlords in trying to get the money out of people who did not get their payments. Many employers before the lockdown, or when the lockdown was announced, withhold the salaries to their workers because they were afraid of what was going to happen. And they did get the placebo from the government that the government is going to assist with salary payments by way of UIF payments. So they actually said, why must we take our money to pay our workers, and then at the end We don't know how long the lockdown is going to last, and resultantly, they withhold their salaries to their workers, and with the placebo, as I've said, to go and make a claim at UIF in order to use state funds to pay their salaries. So unfortunately, we by now, after 5 months, we know that the UIF payments was it did not work as they say. The grants that were told will reach us. 90% of the people who applied at the end of the day never even got approved for it, and it was for mere 350 rand grant a month. But in any event, because of the tremendous number of complaints we received from tenants, we realized that there's a major problem with the lockdown regulations. So unfortunately, at that stage, we were hoping that all these big organizations and political parties, the DA and the Freedom Front and all those on the side of the people organizations, even the EFF, would have approached the court to do something about it, but they never pitched up. So we were forced to approach court on the 14th of May. We've lodged our application. The 28th of May it was heard. We've succeeded on the 2nd of June with an order declaring the lockdown regulations as unconstitutional and invalid. And the technicality comes in where the court gave the minister, and what was, let me first, before I go to the technicality of the 14 business days that were given to the minister to rectify the regulations, let me first explain. The minister, what made our case the most successful that was lodged is the fact that we took only the Minister of Cooperative Governance and Traditional Affairs, Dr. Dlamini Zuma, to court. Because she is the one responsible for the disaster management regulation and the Disaster Management Act. She is the minister appointed by Parliament to give effect. So it went to court. You must take the right person, and in this case, only the minister, to court. All the other cases pulled in the Corona Command Council and the Health Minister and whoever, but all of them are just sideshows at this stage. According to us, we truly believe that the National Corona Command Council does not have any which declared that the National Corona Command Council is not an entity which can be taken to court. The National Corona Command Council is merely a so-called advisory council that was established for the government. Apparently, we know that it's nothing more than a military type of council that was actually established. But in any event, I don't want to go into that. But so what made our case different than all the others is the fact we took Dlamini Zuma to court and no one else. Comply at the end of the day on behalf of the government. And when she was given the 14 business days, did we lose?
Yeah, the signal is very erratic, Reyno. It's still there.
Okay.
Yeah, it's very erratic.
Sorry, Des. I'm just talking now.
That's fine. That's fine.
You must please interrupt me.
No, I want you to explain.
When I'm talking too much, I
want you to explain the history of the
what
case.
So so what the 14 business days were given to Dr. Zuma to change to the regulations in line with the Constitution. Then she had to review and republish it, and also she had to report back to the court on what she has achieved. And that is the technical part which is coming in, because what the court did was that it was an order declaring regulations as unconstitutional and invalid. So in that respect, the court relied on a clause 172 1B subparagraph 2 of the Constitution itself, whereby the court may suspend the operation of the judgment pending a certain period and something that the government must do.
Okay.
And within 4 days after the judgment on the 2nd of June, Dlamini Zuma filed an application for leave to appeal. Now the technicality is further that according to law, once a person files an application for leave to appeal, it is considered in terms of the Superior Courts Act and specifically 18.1, Section 18.1 of it, that the operation and the execution of that court order is then suspended. So how they interpreted this whole outlook or this judgment was that they believed that the period was also suspended. So if they filed it in 4 days' time, it means that there was still, according to them, 10 days left if they have failed with the leave application. So according to them, and unfortunately the court sort of agreed with them on in the leave application that followed, where the judgment was given on the 30th of June. The court said the court case that I relied on was totally irrelevant to the matters concerned, and that the period was never suspended. So the court, in their reasons for judgment, said that there were still 10 days left for the government or for Dlamini Zuma to react to whatever was supposed to do in respect of the court said granted leave to appeal for the blanket regulation invalidity declaration, but the court also took out logical unconstitutionalities that arose, which we basically said was the most important parts that the court did not grant leave to appeal for. And that period then for those ran the remainder of the 10 days according to the reasons for judgment. But we believed otherwise. We said that the 14 days was actually connected to the suspension court gave in terms of section 172 1B2, and that the Superior Court Act is totally irrelevant, or the suspension of it. It's only the court that can actually grant that right to suspend it pending the appeal on behalf or in relation to the period that the court initially gave. So according to us, the invalidity was automatically ended on midnight the 23rd, because on the 10th when we went to court, we said and argued that last night, midnight, it actually is invalid, and up till so there are no regulations before the court to actually contest. So unfortunately, as I said, that the court did not agree with us, because That court case that we used was a court case that was held in Pretoria itself. Judge Nichols was the judge in that matter. But unfortunately, in that judgment, she incorrectly cited the wrong court case reference. So when you search under that reference of the so-called New Clicks case, you came up with something totally different because there were two New Clicks constitutional court cases, and that was never presented. And coincidentally, none other than Wim Trengove was also the advocate of the state in both of those New Clicks cases. So, but if you actually knew about the existence of that New Clicks court case, why didn't you, as an officer of the court, came forward on the 24th of June and mentioned that to the court? He knew at that stage that the court court case that we actually dealt with, which was actually the wrong one, was mentioning the new court case, Clicks case, where it was specifically held by the Constitutional Court that doesn't matter whether you file a leave application, the suspension period is regulated by the court who granted the invalidity declaration. And it's not connected to the common law. At that stage, it was regulated, the suspension period was regulated by normal common law. And now they are trying to say, but now that there is a new act which came into operation in 2013, the Superior Courts Act, it specifically now suspends the operation of a court order. But what the court said in the Constitutional Court case is that the Constitution is the supreme law. Yes. Any law that is not reconcilable with the Constitution is invalid for those purposes, and you need to address it in terms of the Constitution. So what the case yesterday was all about is that there were actually technically three cases before the court yesterday. The first case was a condonation application. The condonation application was to ask condonation or ask the court to excuse us for not filing our cross appeal that I will come in time, because according to the court rules, you must file your application for leave to appeal within 15 days, court days, business days, after the judgment was handed down. So we were supposed to file our leave application on the 24th of June. And why we needed to appeal something is the fact that we also asked originally that declare the national state of disaster declaration also invalid. And the court found on the 2nd of June that decision was rational. So we had to go back to court now and ask that we want to cross appeal on the parts where the government was granted leave to appeal, which is now currently before the Supreme Court of Appeal, in relation to that we don't agree with the court's decision that the national state of disaster was in fact a rational decision. So that case was also heard yesterday in line with everything that was argued. But we first must give permission or get permission from the court to condone the fact that we were 26 days late with the filing of our application.
Yeah, so I noticed that Trengove went after you because of that, obviously.
Yeah, well, we once, with another case that we were assisting with, we once managed to get the condonation for late filing of a leave application for 2 years. So we basically used the same template that was successful in that case as also the template that we've used in this case. So I believe that the judge would recognize the authority that we have cited in that respect, also coming directly from the Constitutional Court, where the Constitutional Court held that there's a discretion in the court to grant leave to appeal and or condemnation for late filing because of the fact that to refuse a person a right to a leave to appeal application, for instance, lodging it late, means that you are actually barring that person from possibly raising very sensible disputes or facts on appeal itself.
Yeah.
So we're not very much concerned with that. The leave application is straightforward. Our basis of why we said that the national state of disaster was irrational is, number one, and this was never contested by the minister in her papers. Yes. At all, and even in the so-called Freedom Front case, Freedom Front Plus case, it was also never mentioned. Most important thing is, we said that the ICD-10 coding system that was used by the World Health Organization in order to allocate the numbers of diseases in a certain class. For COVID-19, that code was only created on the 1st of April, meaning that by the time the national state of disaster was declared on the 15th of March, and also by the time we went into a hard lockdown on the 27th of March, there was no coding system, meaning that there was legally no method which the actual cases for this claimed COVID-19 disease could have been tracked. So where the government came up with 1,000 cases at the eve of 27th of March, just before we went into lockdown, saying that we've got 1,000 COVID-19 cases in the country, it's rising, the rate of infection is deadly, we must lock down now. They could not have got that figure at all, because that figure could only have been established from the 1st of April. Point, case taken, they have deceived us.
Yeah.
It was a thumbsuck number. It was a thumbsuck number. There was no legal way in which they could determine the cases at that stage, and they have ran havoc in South Africa. Everyone was concerned that we're going to drop dead like flies in the street. That is why we also supported the fact that we had to go into lockdown, because we honestly believe that our government would not put fortunately now after 5 months in lockdown, we know for a fact that they have deceived us, they've lied to us, they used thumbsuck numbers. And the very interesting thing that came out of this leave application as well, by referring to the Freedom Front Plus case, is that the Freedom Front Plus and so also all the other political parties, the Freedom Front Plus agreed in that case of the Freedom Front Plus that they have supported the decision of the government to go into or into a national state of disaster on the 15th of March. They've supported her. But interestingly, the Freedom Front Plus, when things got difficult, according to their papers, they suddenly decided that, no, we're not supporting you anymore. We want the reason for why you went into hard law or why you declared a national state of disaster from you, and they put that claim in their papers, asking the court to provide that information. But now the logical question is, but wait a bit, Freedom Front Plus, tell us, if you support the decision of government on the 15th of March to declare a national state of disaster, and you are asking the proof that backed that decision, only now it means that you yourself and all the other political parties did not have that information too. So you all backed something irrationally without having the facts before you. And that is a total treason towards all the people of South Africa. They have all deceived all of us because they never had any backing for what they claim. That is our basis of argument.
Now, that to me is a very good argument, and I have spoken about this at length, that all the parties in Parliament represented there stood behind Cyril Ramaphosa when this lockdown was announced. And they stood behind him again when the extension of lockdown was announced, Reyno. So I like the fact that you use the word treason, because these people did something. They don't belong in Parliament, in my opinion, because how can someone that cannot challenge science or get proper scientific evidence represent us there? And this is why I personally have a huge problem with the system that we have at the moment that elects people like that.
Yes. No, I totally agree. Des, I've noticed that you did indicate before that you're running for another meeting. I see that it's 25 to 10 already.
Yeah.
So let me just quickly wrap up the basis. I think everyone can go and now that I've explained the background of why we came to that point, we basically said that there's a special application that we so-called Section 18.3 application, which basically asks the court that pending the outcome of the appeal, the court must make the order operational. Because sitting with or under these circumstances, and we could not have we need to get urgent leave in some way now. That many people have told me, you know what, it seems if the case that you had, the order you got on the 2nd of June means absolutely nothing. Unfortunately, the minister and the government have pushed it. They have totally abused the court processes to their favor because they know that they can appeal and appeal and appeal the case after the case, and they can literally plaster us against the walls of the courts permanently until they get their answer. And this is the only way in which you can confront or challenge the court order that was given to you and tell the court, you gave that order, the minister doesn't want to comply. What are you as the court going to do about it? Because actually they are making a fool of the court processes at this stage and of the judiciary, meaning that the people believe that the courts mean nothing against the government. And the moment when you tell that to the judiciary, which we have specifically done in our papers, they will tell the government, you know what, up to a year and no more. We must give the impression to the people that you can still get justice. Otherwise, if the people don't believe in the court system anymore, then there is no democracy, there is no constitutionality in this country, and then we are totally chaos. We are on the brink. If this application of us, the importance of this is, if it does not succeed, we can honestly know that the court system does not work for the people, and we as the people need to do something about it. We don't want to use the word of revolution because it's normally associated with violence. We don't support violence from our side, but we do believe that we as the people can then come up and revolt. We can basically defy. That is the best meaning to say. A revolt is nothing but the government, and that is how close this court case is actually bringing our freedoms. We can either now rely on the court and continue go back to the normal life we know, or we're going to fall off on the other side and know for a fact we need to take take this further as the people and proceed. That's basically. I believe that we will have other occasions to go into nitty-gritty of the court case and what it means. But I think let's maybe leave that the moment when we have the judgment, most probably and hopefully sometime next week.
Yeah, it'll be great if we can get the judgment in next week. It looks like the judge knows that this is urgent. By just looking at his facial expressions, it seems like he understands what you were talking about right now, Reyno. So I believe he's in the hot seat. He has to represent the judiciary, as you say, and as you say, if the judiciary cannot find for the people, well, we are in serious trouble. We're not in a democracy, and I don't believe with the things that our government is doing currently. But if the courts can give us relief, that part of the democracy is still working, and that is very important. And I want to thank you for your efforts you've put in. We've had some problems with the live stream, so I actually want to do a proper recording with you at some stage where we pre-record and we upload something with regards to the details of the case, just so that people can go and listen to it again. So thank you very much for coming onto the live stream. I'm running into a meeting in 20 minutes. The people have started to arrive already. But thank you for taking this time. Thank you to all the viewers for watching this. This is not an interactive session that we're having right now because there just wasn't time for that. But I'm sure Reyno will be back. And I want to ask all of you to go to the Liberty Fighters Network website. Go and see what the Liberty Fighters Network is about. Reyno, is there any other place where the people can make contact with you, make donations to your cause? Because obviously you need donations to do what you're doing.
Yeah, no, thank you for mentioning that. We are not greedy at all. If we were greedy in any way, we would have told the people that we need a 1.5 million rand to fund the legal team, which people know we don't have at this stage because we can't afford them, and hence the reason why I'm doing it in person at this stage. We don't tell people that please donate to us or force people. It's all voluntary donations. Go to our website. We've started putting a link for a Mobi page, which we find is very, very safe. It's not like PayPal. It's something that people can use. So on our latest articles that we've published, you will see on the top that there is please make voluntary donations via MobiPay. Then you can just click that link and it's very safe and simple. Otherwise, communicate with us. Our contact details are on our website, and we'll provide you with our banking details. But that is something that I've learned to operate with a bare minimum. That is what Liberty Fighters are all about, and we're not living in lavish lifestyle, very humble. So if there's anyone who can support us with anything, it doesn't have to be money. It can be even airtime or stuff like that. We more than grateful for that. Thanks a lot for asking that. Thank you, Des. All the best for your meeting.
Okay, Reyno, thank you very much, and I will let the viewers know when I'll be chatting to Reyno again in future. And this channel is open, Reyno, for you to come on for anything you want to announce or let the people know. I know I'm not the largest channel out there, but we have some people that are watching and sharing. And thank you to all of you, all of the viewers that have come in and actually watched this live interview. I need to move over to the venue now.